Here we go. Handling investigations is what you're all here for this morning. If that's not the session you're expecting, then join the next one. But this is what we're covering this morning. So let me just do a few brief introductions. So good morning, everybody. Firstly, and a very warm welcome to this People Matter webinar. So for those of you who don't already know me, my name is Melanie James and I'm a partner in our employment, pensions and immigration team. And I'm joined this morning by my colleague Tom Hassoun, who's a senior associate here in the team also. And so for this morning's session, we're going to be taking a look at handling investigations. And before we get into it, I just want to cover off just a couple of housekeeping points. So first, this webinar is the first in a mini-series about disciplinary and grievance processes. So just a very quick plug, actually, for the next session, the next webinar in the series that's going to be taking place in the new year. That's the 18th of January. So that's the date for the diary if it's not already in there. That one's going to focus on the next stage, which is the hearing itself. Tom and I are obviously talking about the investigation stage today. The agenda for this morning. What we're going to be doing is covering sort of 5 key aspects of the disciplinary investigation stage. These actually, the things on the slide are really about a disciplinary investigation, but they can be adapted slightly to also apply, obviously, to a grievance situation where an investigation is in play as well. So what we'll be covering off is framing the allegations, suspension, choosing the investigator, assembling the evidence, and then last but certainly not least, writing up the report. So that's what we'll be covering. Without further ado, I'm going to now hand over to Tom, and he's going to kick us off with how to frame the allegations. Tom.
Thanks, Mel. So this is an often overlooked but incredibly important part of the investigation process. And as we'll go on to see, ensuring the allegations are framed as accurately as possible at the start can really help support the decision makers in formulating clear outcomes later in the process. So if we take a look at the next slide, we've set out here 3 key reasons why the allegations are so important. Firstly, they provide a clear framework for the scope of the investigation. The allegations also ensure the employee knows the case against them, which is crucial for the overall fairness of the process. And finally, it provides a focus for the decision maker in terms of helping them establish the ultimate decision. So understanding how important it is that the allegations are framed as accurately as possible, I suppose the obvious next question is, well, how do we go about achieving that? If we take a look at the next slide, as is highlighted by the heading, being clear and precise is key. So as a starting point, you need to be asking questions such as who, what, when, where, and how, and use that as a foundation for padding out the allegation. You also want to be thinking about things like whether there are any witnesses and also what the act or omission amounts to, i.e., is it an allegation of a particular type of misconduct under a specific policy? So we thought it'd be helpful to take a look at a couple of examples here to see how this can play out in practice. And these facts are actually based on a recent tribunal decision involving the dismissal of a banker from Citibank, which you may have seen reported in the media. So if we take a look at the allegation on the next slide, you'll see that this is far too broad for the employee to properly understand the allegation they're facing. For example, it's not clear what the expenses claim was for, what the non-business expenses were, or which policy they're alleged to have breached. And if we take a look at the second slide, you'll see here, this is a much better way of framing the allegations. It's more detailed, includes dates, details of the expenses, details of the specific policy, and it sets out how the expenses claim is said to have breached the policy. And it's separating it out into 2 allegations, the first about a breach of policy and the second about the employee lying. Well, it helps the decision maker by giving them a clear remit to make decisions about both issues rather than conflating them into one allegation. Now, I do appreciate this isn't always a straightforward process, and there are some common pitfalls we tend to see here, some of which we've set out for you on the next slide. So if we just run through these, firstly, in terms of labelling, whilst not always wrong, it can sometimes be counterproductive to use labels or legalistic words such as discrimination or fraudulent. So using the earlier example, to say the employee had submitted a fraudulent expenses claim, well, decision makers are not always easily able to decide these legalistic concepts, and something can still, for example, be a breach of policy without necessarily meeting the legal definition. So give some thought as to whether using legalistic terms is actually helpful. Attributing motive is another trap that's easy to fall into. For example, referring to someone willfully or deliberately undertaking a certain action. Intention is often not relevant and can be difficult to prove. So my steer on that would be, unless it's absolutely necessary, I would avoid using subjective descriptions in the allegations. You'll see the next one that we've put up here is referring to policies. And this one for me really highlights why it's so important to give proper thought and consideration to the allegations at the outset. As we mentioned earlier, it can be helpful to state the policy, particularly if, as in the expenses case, the allegation relates to a specific breach of it. However, do be mindful here of the risks of becoming a hostage to fortune. And an example of that would be stating an employee made a certain comment in contravention of the bullying and harassment policy. So whilst the comment may have been made and may constitute unacceptable conduct, it might not actually meet the definition of bullying itself. Final one there is including everything but the kitchen sink. And this really helps prevent against the parameters of the investigation being too wide. Think about what you're trying to achieve and whether that can be achieved by, for example, just sticking with the strongest allegation. One final thing that I want to mention here before we move on to the next topic is that it's really important the allegations are kept under review. Allegations can evolve or change over time, and new allegations can also arise during the course of an investigation. To the extent that allegations change or new allegations are added, it's essential you inform the employee so they're fully aware of the case against them. You need to ensure they have the opportunity to comment on the revised allegations and start to consider things like whether it's necessary to re-interview any witnesses, reconsider existing evidence, or indeed seek to obtain new evidence. I'll now pass you back to Mel, who's going to speak about suspensions.
Thanks very much, Tom. Yeah, so the question of suspension is one that will inevitably come up when you're in the early stages of a disciplinary and sometimes a grievance process. And it's certainly something to consider when you are looking at embarking on an investigation. So suspension will certainly be appropriate in some circumstances, but certainly not all. It'll really depend on the nature of the allegations that are being investigated. And normally a rule of thumb is that the more serious the allegations, the more likely a suspension will be applied in general terms. The sorts of considerations that you should have in mind when thinking about whether to suspend or not to suspend. So, for example, does the employee present a threat to the business or a threat to any employees, for example? Would the employee's presence in the workplace disrupt or hinder the investigation in some way? That would be another reason to suspend potentially. So, for example, when I mean hinder or disrupt the investigation, things like interfering with documents or evidence if they have access to systems, or depending on the nature of the allegations, is there a concern that perhaps there could be some interference with witnesses or witness intimidation, for example? Very important things to think about. Also, have relationships broken down so that, a temporary period of separation within the workplace would be helpful to enable the investigation to proceed. And also as well, it's not on the slide, but it occurs to me that when thinking about whether to suspend somebody or not, I have a think about, well, are they in the business anyway? Because I do often find that when somebody is the subject of a disciplinary investigation, obviously it's a stressful time. People sometimes will go off sick. So, for example, if you receive a fit note that somebody's going to be out of the business on stress leave for a month, then you're not going to need to suspend them because they're already going to be out of play, as it were. That's another thing to think about. Another key point is that suspension shouldn't just be like the automatic response, the knee-jerk reaction. Do give it some thought first and have a think about whether it's needed and whether it's appropriate. It's important to go through that thought process and show that you've been through that process. Consistency also is very important when considering suspension. So, for example, if you've got two alleged offenders and you're looking at suspending one and not the other, make sure any differences in treatment can be explained and justified as to why they are being treated differently. And also check your policy or contract. You know, have you got the right to suspend somebody? Sometimes that's something that's overlooked slightly. And in truth, any decent disciplinary policy will contain provisions around being able to suspend. And also, a lot of contracts of employment also cover this off. But if not, and your policies and contracts of employment are completely silent on suspension and whether you can suspend or not, just bear that in mind, because you could otherwise find yourselves sleepwalking into a breach of contract issue, potentially, if you suspend somebody when you don't actually have the right to. So finally on the slide, goes without saying in a sense, but try and keep the period of suspension as short as possible. Keep it to a minimum. The length of suspension, really, I mean, there is no legal sort of limit or parameters in terms of how long a suspension should be. And it will really be around, you know, it'll be determined by the size and the complexity of the investigation that's needed. But do keep it under review and try and make sure that an employee is not suspended for a protracted period of time. Just a quick flag for the Acas guidance. So Acas does have some guidance out there on navigating suspension. Some of this focuses around ensuring the employee's well-being, actually. There's a bit of focus on that in this guidance. Understandably, I mentioned earlier, it's a bit of a stressful time if you are, you know, subjected to a workplace investigation. So the Acas guidance, it's worth a look if you're in suspension territory and you're thinking about how best to navigate that. So that deals with suspension. We're going to take a look now at choosing the the investigator, or the investigating officer, as sometimes called. So I'll hand you back to Tom.
Thanks, Mel. So it's really important the right individual is appointed. And so in giving this question some thought, it's helpful to remind ourselves what the role of the investigator is. The role of the investigator is to gather and consider evidence about what did and did not happen and report on the facts. That's very different from determining culpability or guilt, which is something the individual or the panel conducting the hearing will do. If you take a look at the next slide, we've set out here for you some things that you should consider when deciding who will be appointed to investigate. So, first thing to do without failing any potential investigation is consider your internal policies and ask yourselves whether the policy indicates who the investigator should be. For example, does it state it should be the line manager, or alternatively, should it be someone of a certain seniority or different department in light of the nature of the allegation? And following that, we've set out some key considerations when it comes to deciding who should investigate. So firstly, impartiality is key. And in that sense, it's crucial to the overall fairness of the process that the employer is not seen to have prejudged the outcome. Whoever is chosen must act fairly and objectively. And in this regard, you should ask yourself whether the appointment of the individual may give rise to any conflicts of interest, or whether they are likely to be influenced by people involved in the matter. In terms of level of experience, ask questions such as, has the proposed investigator carried out an investigation before? Have they had any training on things like investigations or equal opportunities, if appropriate to the facts? In that sense, it may be inappropriate or unreasonable to expect, say, a junior manager with no investigations training to investigate serious allegations of misconduct made by one of their team against a senior manager. What about workload too? Will that person have the time to dedicate to a full and proper investigation and report? Have they got any upcoming leave to consider, which may disrupt the process? Less experienced managers may require HR support, and if they are going to require such support, you should also be thinking about whether HR support is going to be readily available to the investigator when needed. Remember here the Acas code, which specifically states that it's important that investigations are conducted without unreasonable delay. Another thing to consider is, who will conduct the hearing and appeal if one becomes necessary? So keep in mind the general requirement to have different individuals at each stage of the process in ascending seniority. And in that sense, it's fair to say that deciding who is the most appropriate person to carry out the investigation will often require you to take a step back and start to think about who will be lined up for the later stages of a process if required. I really can't emphasize enough how taking the time to plan an investigation and think ahead can really help you avoid problematic issues later down the line. I'll now pass you back to Mel, who's going to speak about assembling the evidence.
Thanks very much, Tom. Yeah, so let's have a look at the process of actually gathering the evidence. So first, the search for documents. So the document trail, of course, that's going to be critical in ensuring a reasonable investigation. And when I say documents, I say that quite loosely, actually, because the reality is that the evidence extends beyond written documents such as letters, written notices, emails, things like that. And obviously encapsulates digital and electronic information as well. So text messages, WhatsApp messages, Teams logs, phone logs, swipe in and out access records, even CCTV as well. So it's a fairly broad scope. So the search for this sort of information needs to be proportionate, really, to the allegations. And the test, in terms of where those parameters are, is just to carry out as much investigation as is reasonable in the circumstances. So it doesn't always necessarily mean, turning over, looking under every stone, as it were. And in terms of the scope, the search for information is really around trying to find facts that will support or corroborate the allegations, or indeed disprove the allegations or undermine them in some way, so that you get a balance in the investigation, if possible. Top tips also for witness interviews. So I've talked about gathering documentary and sort of digital evidence, but let's not forget the other type of very important evidence, which is witness testimony. So an investigation is always going to involve speaking to witnesses and taking a note of what they say, in addition to sort of the documentary side of stuff. So in terms of who the witnesses will be, if you're in a disciplinary matter, the investigator clearly would need to speak to the accused, the offender, the person who is alleged to have committed the misconduct. And if there is a victim of the alleged misconduct, then that person clearly will need to be spoken to as well. In the case of a grievance scenario, the key witness really will be the complainant, the person that's brought the grievance in the first place, along with the person, if there is one, against who is the subject of the grievance. Now, sometimes there might not be an individual who is the subject of a grievance. So, for example, it can be a peer, a colleague, a line manager, something like that. But sometimes it's actually just against the organisation. So things around, your working conditions and things like that. But in addition to those people, the complainant, the offender, etc., the investigator should also speak to colleagues who saw, heard, or otherwise bore witness to the issues being investigated. So people who will have information that are relevant to those. So set out on the slide are some top tips for conducting witness interviews. I won't go through all of those, but if I were to highlight just one, I'd say that probably the key one is to remember the scope really of the investigator's role. It's really to fact find. The aim is to establish facts of what happened or what is more likely to have happened. So the investigator is not to decide whether the allegations are substantiated or not. That's not within their remit. It's not within their remit to decide what sanction, if any, is appropriate. It really, as far as it goes, is for the investigator to do the fact find and then reach a conclusion as to whether on the face of their findings, there looks like there might be a disciplinary case to answer, at which point it moves on to the next stage of having a disciplinary hearing. So just a quick whiz through some examples of good questions up on the slide. I'm not going to go through all of those. I mean, you can see them on the slide, but these are the sorts of things that would typically be asked of witnesses. And you'll see that they're open questions, inviting witnesses to give their account of events without sort of leading them in a certain direction or asking a loaded question or perhaps suggesting an answer to them. Certainly for grievances, very important question to ask the aggrieved employee is what's their desired outcome? You know, the employer won't necessarily always be able to deliver on what the employee thinks a good outcome would look like, but it's always helpful to know at that point what good looks like to the person that has raised the grievance. Okay, so last but not least, then I'll hand back to Tom to take you through the final piece around writing the report.
Thanks, Mel. So the investigation report is a key document. It's essentially the end product of the work that has gone into conducting the investigation. Not only is it going to be heavily relied on by the individual or panel conducting the hearing, but it'll also be a key document in tribunal proceedings, if, for example, a dismissed employee went on to bring a claim. So understanding the importance of the document, you'll see on the next slide that we've set out some top tips for you. I'm just running through these in order. So firstly, the report must be logical and clear. And in some ways, it goes without saying that the more logical and clear the report is, the more help it will be to those making the decisions later down the line. One way you can kind of support that first point is by including a timeline of events, which is often a really helpful way to present matters clearly. The report should also deal with each allegation separately, and this really feeds into the earlier points we were making around framing the allegations as clearly as possible at the outset. The report should also identify whether there's a case to answer, and this will generally be a conclusion as to whether or not any formal action should be taken. But, and this is really, really key, leave the decision making on outcome and sanction to the individual or panel conducting the hearing. As we mentioned earlier, it's not the role of the investigator to give their view as to whether any sanction should be given. So just looking at the next slide, you'll see the heading here, which says report on what is likely to have happened. Now, on the face of it, that may seem fairly obvious to you, but it's not uncommon you see investigation reports which strain to giving a view on culpability or sanction, which can, without meaning to, inadvertently impact the overall fairness of a process. Another thing to consider is, if I'm just reporting on the facts, well, what happens when certain facts are in dispute or it's not been possible to substantiate a claim? Well, we've broken down on this slide for you 3 potential ways in which the facts can be reported. So if we take the first, this is where the facts are not in dispute. Touching on our expenses example from earlier, this would be something like the expenses policy states spousal meals and travel are not reimbursable. It's a simple factual outcome which is not in dispute and can be clearly evidenced by the policy wording. Looking at the second then, where the facts are in dispute, again, using our earlier example, this might be something like the employee claimed for a meal for his spouse. He says he ordered 2 meals for himself, but the manager says he believes the employee ordered 2 meals for him and his spouse. So it's clearly setting out 2 different accounts gathered as evidence in the investigation, and it is open to investigators to reach conclusions on the balance of probabilities as to what did and did not happen. But that should be clearly supported by the evidence gathered in the investigation. Finally, if there are any unsubstantiated claims, consider not only just if any further investigation is required to establish those facts, but also whether it's reasonable to do so in all the circumstances. If the investigation was ever scrutinised by a tribunal in the context of an unfair dismissal claim, it's important to bear in mind that an employer would not be expected to have carried out the best possible investigation it could, but instead one which is reasonable in all the circumstances. So if further investigation is not required or not reasonable, it's sensible to specifically state in the report that you've been unable to draw a conclusion. Just keep in mind here that this is really about arming the individual or panel conducting the hearing with all the material facts they need to make a reasonable and informed decision. So moving on to the next slide, the question we pose here is, well, what is the role of HR at this stage of the process? This is, of course, assuming HR itself is not leading the investigation. HR's role is essentially to give advice on questions of law, procedure, and process only. They should not be giving their opinion on outcome or seeking to influence the report. So whilst HR may have all the best intentions, if that remit is exceeded, you risk the process and any potential dismissal being deemed unfair. So if we take a closer look at the slides, HR can do things like making the investigator aware of the steps they need to take to ensure a fair and sufficient investigation takes place, can remind the investigator to support their conclusions with evidence, and they can provide general advice on the usual format for an investigation report. Now, for those who may not be well versed on how to approach pulling together an investigation report, I will just say on that point that Acas have some really helpful resources available for free online. There's actually a template investigation report, which could act as quite a helpful starting point. On the other hand, HR certainly should not be writing or redrafting the report, giving their opinion on whether they think the employee is guilty or innocent, or looking to change any of the investigator's conclusions. As I said earlier, that's almost certainly going to significantly increase your risk around things like unfair dismissal. One final thing to bear in mind here from a claim perspective is that HR drafting input on investigation reports may well end up being disclosable in subsequent tribunal proceedings. So do think really carefully about those risks when managing this stage of the process. I think that brings us to the end of the main section of the presentation.
Great, thank you, Tom. So we've got a minute or two left for some questions, and we have got some questions in the Q&A, some of which may have actually been covered by that last piece actually that Tom was talking about in terms of writing the report. But we'll pick up on as many as we can in the time we've got left. I'm conscious that we're reaching 10:30 now, so those of you that have to leave, obviously, please do dial off. But Tom and I are around for a couple of minutes, so we'll rattle through as many as we can. I'll pick one up first so that Tom can have a little look in the Q&A now he's finished speaking. But let's have, so here's an interesting one. How can you come to a conclusion when the evidence, in quotation marks, is one person's word against another? Great question. So in terms of coming to a conclusion at the investigation stage, the conclusion really is around, do we now move to the next stage of a disciplinary hearing? So you will always find probably with the investigation, there's going to be a conflict of evidence. You can ask various people about the same set of events and you'll get various different recollections and accounts. So really, when you're dealing with investigations and then deciding culpability later on, the test is balance of probabilities. So even if there's actually no proof and you don't really know 100% for sure that the person is guilty as charged, if on balance, taking everything into account, you think it is more likely than not that they are guilty, then it's okay to reach that conclusion, even though there may be conflicting evidence around it. So you never have to have 100% proof in order to apply a disciplinary sanction. But great question.
Thanks, Mel. So I've seen on a couple here about the right to be accompanied to investigation meetings. So a few points here, I think. So firstly, employees have no statutory right to be accompanied to an investigation meeting. The statutory right to be accompanied is actually set out in Section 10 of the Employment Relations Act 1999, and that relates to disciplinary or grievance hearings. Another thing to note here, I suppose, is whilst it's probably unlikely, do keep in mind that a contractual disciplinary procedure may give such a right. And also, consider things like reasonable adjustments if you're dealing with a disabled employee, for example, who may qualify for protection under the Equality Act. I think one final thing to say on this as well, and it is fleshed out in the Acas investigations guidance, is that aside from the statutory position on this, there can sometimes be value in allowing people to be accompanied by workplace colleagues, trade union reps, or even friends or family members in certain circumstances. And position can be a little bit more nuanced, I think, with regards to grievances. And when you look at the guidance, what it does say is, whilst there's no statutory right, sometimes if it's a particularly emotive subject, having someone in or a companion attend with an interviewee can make them feel more comfortable and more willingly to talk openly about the matter. So that's something to weigh up on that point as well.
I'll just pick up a quick one here. Do you have an example of a report, so an investigation report template that we can share? There's a great one on the Acas website, really good structure, really help you pull together a decent report. So that would be your first port of call. I think that's a really good, useful tool. I've used it myself previously, so I can vouch for it. It's really good. There's somebody here that struggled to access the session, missed the first 10 minutes. The recording, yes, it will be shared, so that will be made available later on the website. Are there time deadlines for a grievance appeal? No, there's not. Unless your own policy sets out, we will get back to you, or we will do the stage within this time frame, then you're not really committed. And even if your policy does set out a desired time frame, sometimes you need to flex that. Perfectly fine to do it. Just let the employee know that if there is a delay, when you do expect to be able to get to the next stage of the process, that is fine.
One quick one I've seen here, Mel, about how detailed do you need to be in the allegations? So certainly don't need War and Peace, but just keep in mind, obviously, what we said at the very outset, that for the fairness of a process, it's absolutely crucial that the employee knows the case against them. So if you use those initial questions to pad out your allegation, take a step back and think, is the employee going to fully understand the case to be able to progress on that basis?
Right, I'm conscious of the time now. We've gone 5 minutes over, and I don't want to take up any more of people's time than, I'm grateful that you've already given us time out of your busy days. Tom, is there any final bit you want to pick up or talk about before we sign off?
I think there was one thing one just final question, I suppose. I mean, there's so many in here, we're just not going to, unfortunately, have time to get to them all.
Well, we could pick them up also as well for those in the audience that are attending the next webinar in January. A lot of this stuff actually could creep into that session as well, so you could potentially have your question answered there if we can't get to you today. Sorry,
yeah.
Tom.
Sure. No, I think one final thing I'll touch on that I've seen mentioned a couple of times about references to Acas and whether or not you need to follow to what extent you're obligated, I suppose, to follow the code. But so the Acas code is intended to provide practical guidance to employers and employees on disciplinary and grievance investigations. So failure to follow it does not in and of itself make an employer liable for proceedings. However, what I would say is that employment tribunals must take it into account when considering if an employer has acted reasonably or not. And one thing to keep in mind here is that in say, an unfair dismissal case, the tribunal can adjust compensation by up to 25% either way, if either the employer or employee has unreasonably failed to comply with the code. So, as I say, it's not going to make you liable for proceedings in and of itself. I would certainly be striving to act in accordance with it wherever you can. And actually, the guidance is really helpful. So, yeah, just touched on that point.
Perfect. Okay. Great days, everybody. Thanks again, and goodbye from us.
Thank you.